Okay, this really is an interesting one. Now, if you believed what you've seen on the internet so far, if anyone has talked about this yet, it's that you could basically, in the state of California, walk around anywhere you want with a loaded handgun without a concealed carry weapons permit and not have to worry about the law or any repercussions because a judge said that this rule was unconstitutional in the state of California. Is that the case? Well, I'm not a lawyer. This is not legal advice, but I'm going to say do not go do that without understanding that there will likely be repercussions. What you do as a free man or woman in society, I don't care. If you're not hurting anyone, I don't care. I'm not going to stop you from breaking the law. Might be a good idea to understand the law so you can not get caught. But again, not a lawyer, not legal advice, just a dude on the internet. So let's talk about what's actually going on, because a lot of people are of the opinion that this means that they can just go out and that precedence has been set and that anyone can carry a gun anywhere in the state of California. It's not really that simple. Now let's talk about what actually happened. So in the city of Sacramento, a Superior Court judge saw that this man was being charged with several crimes, two of which being loaded handgun in public, I believe, and carrying a firearm without a permit. Those are the two that you'll typically get busted with if you're walking around carrying a loaded handgun. Now, there are some exemptions to that. We're not going to go into those. But in this case, they tried to say, instead of pleading guilty or not guilty, they said that because of the decision in Bruin, because the state of California did not at the time and does not currently have a legal means or a constitutional means, because when I say legal, I mean does not have a constitutional means for an individual to carry a firearm, because on the books currently, the state of California, the law still requires good cause. Now, regardless of that being unconstitutional, maybe certain sheriff's departments, certain city police departments are not enforcing that requirement. The law still does say that good cause is required. We're going to talk about SB 918, the really, really bad CCW law that's going to be replacing the current laws, and that's really, really bad. And this specific case, in my opinion, could potentially have huge implications towards them trying to pass that even quicker and getting it even worse. Instead of saying that it was either guilty or not guilty, they said, hey, this law, even if the state said and proved everything and was able to prove that I did these things, it still wouldn't matter because there was no crime committed, because under the current Bruin precedence that has been set, there should be no crime because no crime has been committed, therefore they can't charge him. So it was demurred. Now, I'm going to have a link to this Reddit thread where some actual lawyers are touching in on this because, again, just a dude on the internet. I might copy Berador's comments over there. Now, you might be thinking, well, who got this win? Well, it was just a public defender, which is very cool of them to do that. He said that many public defenders were trying to use this and discussing how they would use court cases like this to defend their clients and that kind of thing. And I think this is really interesting. Now, you might be thinking, okay, so that's a precedence, right? No. This is just one judge. This doesn't even affect other judges in the county. This does not affect any other judge. This doesn't even necessarily affect this judge in the future. This is just this judge saying that in this specific situation, there is no crime. Does that mean that you should rely on this sort of thing happening for you if you choose to get caught with it without a CCW? Because in many counties currently, even in states or even in counties like LA, the processing times, even if they are processing them, is upwards of a year. So many people are choosing between getting caught with it or getting caught without it. It's up to you to decide what you do for yourself. However, if you choose to get caught without it, I would not try to bank on this sort of get out of jail free card happening for you. I think they put it, what's the odds of lightning striking twice? Yeah, I think that's a pretty good way to look at it. If you choose to follow the Constitution as your guide of what laws you follow and what laws you don't follow, I'm going to leave that entirely up to you. You just have to understand the risks that you might be taking. I'm not saying not to do anything. I'm not saying to do anything. I am just saying, hey, make decisions with the best possible information. Best possible information probably does not include relying on a dude on YouTube who is not a lawyer. Keep that in mind. Now, we mentioned SB 918. Now, this is a bill in the state of California that would potentially make it so that anywhere, Anywhere that is not your home, anywhere there's not a business that has explicitly said to you, hey, come on in, bring your gun in, come carry here. This is a bill that would basically ban any person with a CCW permit from carrying anywhere in practice, because not only does it add to the list of prohibited places, making it so common that basically any city, you would be able to drive through certain locations, not park in most parking lots, not park on most streets, not step foot on most sidewalks, can't go to any parks, can't go to any restaurants, can't go to any building that could even possibly be receiving state funds or government funds and be government owned. This is a bill that would basically ban concealed carry everywhere. And this is a bill that is very reactionary to the Bruen decision. Even though the Bruen decision said that you cannot just make, for example, I believe they gave the entire the entirety of Manhattan, you couldn't just make entire specific cities or specific areas, towns, regions, sensitive locations. It seems as if the state of California is trying to work their way around that and pass a law that would in practice make everywhere, or at least probably 75% of the landmass of California, sensitive locations where you could not carry a gun. Would this be constitutional and hold up in the courts? Probably not. Would it still take years and years and years to pass? Yes. Would many people like me, like you, potentially get hurt in the process because, hey, you're carrying your gun, you're walking down the street, you have your concealed carry permit, the gun that you're carrying is on the permit, you're not under the influence of any drugs or alcohol, you're walking down the street on the sidewalk, and then you look to your left, and you realize that the building to your left and the sidewalk adjacent to it the building to your left is owned by a government entity, and you cannot step foot on that sidewalk. You've now committed a crime. You've now committed a gun crime, a crime that could potentially get rid of your CCW. A crime that basically means in that moment, you are not legally carrying. Your permit does not hold grounds there. You are unlawfully carrying, according to the state. Does that sound like a situation where many people could potentially get hurt because they weren't aware that certain buildings happen to sell alcohol inside, and because they're on the sidewalk outside of it, they could get in trouble? Does that seem right to you? This is what I think is going to happen in the future. This is just me speculating. We've seen now Bruen. California did not like that. They did not like that at all. We see that they drafted SB 918 as a way to respond to that, to basically strip you of your right to carry, even if you go through and jump through the hoops and dance like a good boy, dance like a little dancing monkey when they say to. Even if you do all that, they are going to try to find a way to restrict your rights. SB 918 is that route. I see this happen with this guy getting off because there is not currently a legal means for you to carry, because currently the laws on the books are unconstitutional and therefore are not valid. Because of that, I see a lot of pressure. I believe there will be a lot of pressure put on these state lawmakers to pass this bill in its worst possible state. I think they're going to try to pass this bill incredibly, incredibly hard. Now, if you're looking for organizations to support in things like this, to try to challenge things in the future, my big recommendation right now, if you live in the state of California, is the California Rifle and Pistol Association. We're going to have some very exciting news from them coming soon. But the CRPA has been the organization that fought for Duncan v. Bonta, formerly known as Duncan v. Becerra, the magazine ban. They have a whole lot of other stuff going. So CRPA, Michelle and Associates, very great people. If you want to support local organizations, that would be my recommendation. You guys know the drill. Have fun, be safe, stay dangerous.